Hello and welcome to the fifth webinar in our Family Law Webinar Spring Summer series. And today is the first webinar in our junior series. Now, recordings of our previous webinars are available on 42 Bedford Bros website or on YouTube. If you wish to sign up to the remaining webinars, please visit our website or you can contact Chambers. Now, my name is Hannah Cox and sitting with me is Catherine Howes. We are both junior barristers at 42 Bedford Row. I specialise in family finance and private children law. Catherine specialises also in family finance, private children law, as well as employment law. I'm going to hand over to Catherine, who can introduce the topic in a bit more detail.
Thank you. Today we're going to be talking about FDR appointments. Our talk is aimed at junior and trainee solicitors, and our aim today is to help you to ensure that clients and their cases are as prepared as possible as they can be for FDR appointments. We're going to be sharing with you some practical tips and guidance on preparation for FDRs, what happens during FDR, and what to do after an FDR has taken place. Just to give you a bit of background and context about FDR appointments, they've been around since 1996, since they were introduced on a trial basis. They have now been incorporated into the family procedure rules since June 2000. They have now become a central feature of financial remedy procedure in England and Wales. Per family procedure rules 9.15, the court must direct that the case be referred to an FDR appointment, and that is unless the first appointment or part of it has been treated as an FDR appointment and that FDR appointment has been effective, or there are exceptional reasons which make referral to an FDR appointment inappropriate. In terms of what an FDR is, they must be treated as a meeting held for the purposes of negotiation and discussion. I'm going to be starting now in terms of preparing for an FDR, and we start with the basics and the importance of getting the basics right. We start with the ES1 and ES2 forms and also a composite chronology, which must be filed no later than 7 days prior to the FDR appointment. We also have the bundle, which is of course important. We need to get that index agreed with the other side if possible and sent in good time. Also have in mind to compliance with practice direction 27A. Just to note here that enclosures, for example, enclosures to a Form E aren't usually seen in court bundles, but please do ensure that they are sent to counsel separately. It's also a good idea to have an eye to the size of the bundle. For example, practice direction 27A says that there needs to be permission for more than 350 pages. If it looks as though the bundle is going to exceed that, make sure to make an application in good time. Another thing to consider is the Form H, in which you set out the costs incurred and expected to be incurred up to the next hearing, and these should be filed and served not less than 1 day prior to the FDR. It's also a good idea to have an eye to what's going on in terms of the divorce proceedings. Whilst an FDR appointment can go ahead without a decree nisi, it's always a good idea to check whether it has happened, as that can affect implementation of any orders made at an FDR. Now it's time to start preparing for the FDR in earnest. A good place to start is by looking at the order that was made at the first directions appointment to ensure that there has been compliance. Just a note to say here that if non-compliance does look likely, a good first place to start is just discussing it with the other side to see if you can agree to any extensions for any directions. If that isn't possible, then think about making an application to the court, but also think about the effectiveness of the hearing and as to whether there may need to be an adjournment of the hearing or a vacation. It's best practice not to leave it too late or on the day. Now let's think about some of what those directions that you might be complying with look like. We'll start with valuations. Some common valuations that we see are, of course, property and land valuations, but there can also be chattel valuations, for example, cars, expensive jewellery, things like that. The difficulty is, if those valuations are outstanding, it can be difficult to have an effective FDR, especially in terms of property valuations, as these often form, in needs cases especially, a large part of matrimonial pot. It's good practice not to wait until too late and to chase those valuations, and make sure to chase them in good time if they haven't been received. It's also a good idea to go through those valuations with the client prior to the FDR to make sure that they understand those valuations. And if they don't agree with those valuations, you need to be prepared to tell the judge why they don't agree with those valuations. Next up, we might see expert reports, and some common examples would be pension reports, CGT, or tax reports. Again, it's important to say that if those are outstanding, it can be difficult to have an effective FDR. It's again important to go through all of these reports with the client. You should also consider whether written questions might need to be put to the expert. For example, written questions can be put under Family Procedure Rules 25.10, but the time limit would be 10 days. Due to that fairly short time limit that you have to put those questions, I should say it's 10 days from the receipt of the expert report, you should consider when you receive the report whether to talk to the other side about agreeing to extend that deadline, or again putting an application in good time. The final thing you might be looking at in terms of compliance with any FDA order would be replies and disclosure more generally. Dealing first with your own client's replies, it's best to deal with these as soon as possible after the FDA. Documents that you're required to obtain following the FDA for replies may be more difficult to locate and to obtain by the client. For example, they might have been missed from the Form E, or they were unable to obtain them when doing the Form E. Then looking at the disclosure which has been given by the other side, if you're dissatisfied with disclosure, it can be helpful to informally raise this with the other side by an email, setting out what you consider to be missing in the first instance. You might also then consider drafting a schedule of deficiencies, and there may also need to be consideration of third-party disclosure orders. Again, with the issue of disclosure, you need to be considering whether an FDR can still be effective, or whether you need to be considering moving it to a later date so that you can get all that disclosure that you need. Parties should note that they're under a duty to provide full and frank disclosure. However, you should be bearing in mind the overriding objective, which is to enable the court to deal with cases justly in ways that are proportionate to the nature, importance, and complexity of the issues. I'll now be handing over to Hannah.
Thank you, Catherine. So hopefully you have your disclosure, you have everything that you need, you've got your bundle all looking nice and pretty for the judge. Really, once you've got all of the information, you need to start turning your attention to mortgage capacity, reports, property particulars, and of course the very important without prejudice offer. Now, ideally, although I personally don't find it's pretty standard practice, that you actually get your mortgage report in first. The reason being that although of course you need to know what the value of the assets are, it's actually really helpful to know what mortgage capacities you effectively have to play with when considering what your offer might be and the kinds of properties that you would put forward. For example, realistically, what are the housing needs going to be for these parties? What could they realistically afford? So once you have your mortgage capacity reports, you consider property particulars and then of course your without prejudice offer. So just starting with mortgage capacity reports, now they are very important. I think it's fair to say though, they can sometimes be overlooked. Fairly often, I have come across cases where one party may have put forward effectively a single page setting out what their maximum mortgage capacity theoretically could be. Now, the difficulty and the pitfalls, if you like, with these online mortgage calculators, or however the individual got to that figure, is the lack of detail that it gives counsel or solicitors or whoever's doing the FDR to make arguments if, for example, there are concerns over the reliability of that figure. It doesn't give information such as the length of the term, because of course, if you are dealing with parties who are older and this is a figure on a 20-year mortgage term, it's probably not going to be very helpful or realistic if this term takes them to actually what would be 75 or even 80, for example. It's also really important to see what information you're actually giving to the mortgage expert, what information is going into this. Because if there are concerns as to income, etc., then clearly if that information is there, it's easier to make submissions on that. So there are actually huge advantages to pushing forward quite a detailed mortgage report. And again, I think it is something that can often be overlooked, but I would encourage you to kind of think a bit more about mortgage reports, what information do they need to include, what can they say, and potentially what submissions could be made in the hearing to help your clients. The other point to note, if, for example, you receive the other side's mortgage capacity report and it is actually one of these one-page documents, often, certainly within the standard orders, there is a paragraph of provision for you to put forward your own evidence in regards to their mortgage capacity. It's something worth considering, because certainly if you want counsel to make submissions at the FDR that the other side's mortgage capacity report is not accurate, if you have simply no evidence to counter it, it can be very difficult to persuade a judge. So if you do have the opportunity to do that and your client's happy to do that, I would encourage you to go down that route. When perhaps the final thing just to consider, of course, is not only the headline figure of how much can your client or the other side borrow, but what are the repayments going to be? Because of course it's all very well saying, well, in theory, the husband or the wife could borrow this amount, but actually it wouldn't be affordable, the repayments. Again, it's more information, it's more assistance that you're giving to make sure at the FDR you can make the submissions you want to make and that your submissions are persuasive. So you've got your mortgage reports, you then turn your mind to property particulars. Now, property particulars are hugely important. As we all know, many cases, the majority of cases are needs-based, and primarily the need that we are considering within those cases is housing need. So this is your opportunity to put forward your evidence to justify and say this is what the party's housing needs are. This again, though, can be an issue that is overlooked. So let's say I have a case, I'm sure you've all had one like this before, where you have lovely property particulars for your client, beautiful properties. You then turn the page and you look at the properties that your client has suggested for the other side, and they are, shall we say, somewhat to be desired. The difficulty with that kind of situation is, unsurprisingly, a judge may form the same view, that clearly we have significantly better property particulars for one and not the other. Now, the reality is, in all likelihood, that isn't going to be the answer that the judge agrees with or the indication they're going to give. The problems that you can get into is that the judge therefore has limited evidence to effectively go somewhere in the middle, and it may well be somewhere in the middle that is appropriate. So it makes it harder to effectively try and control or have greater control over the indication, particularly in respect of housing needs. The other thing, in a similar way to mortgage capacity reports, I would encourage to distance yourself from black and white photographs, for example, from one-page, very short examples from online. Try and get as much information as you can. When you click on the document, whichever website you've gone to, Ordinarily, there'll be many photos. Include them all. Include them in colour. Make them look as nice as possible. It just can be really helpful, and often there's useful information as well in the details to the property. For example, floor plans can be very helpful. Other things to look out for, obviously, is it leasehold? Is it freehold? How many years are remaining on the leasehold? Is it shared ownership property? So again, it's just the more information you put forward, the more helpful it is for submission. Now, when considering housing needs and property particulars, if perhaps the answer isn't to put forward lovely properties for your client and less lovely properties for the other side, effectively, what do you do? The first question I would encourage you to ask is, putting aside what the client may tell you for one moment, what do you think realistically are the housing needs going to be? Now, many times a client will say, well, I'm looking after the children for more of the time, and therefore that justifies me having a greater housing need. In my experience, those kinds of arguments really aren't being persuasive with judges in the courts, even in cases where there is really very limited contact between a parent and a child. Even then, courts seem to be really reluctant to not enable them to have a second or third bedroom so that the children could stay over in the future. When even in cases where there isn't contact, but perhaps there are children at proceedings, perhaps the children are still very young. So I certainly wouldn't want to rely solely upon that argument in trying to argue as to why my client, for example, has greater housing. I would encourage you, though, to get as creative as you like when trying to justify why their needs are greater. So, for example, when a few months ago I had a client who had a dog, and the judge was quite happy to agree that therefore he required a garden, whereas the other side did not, for example. Other arguments that might work is particularly if your client works from home. When I always think a home office is a bit of a luxury, but judges seem quite receptive that if there are sufficient funds, that potentially your client does need an additional bedroom for a home office, particularly if their work is confidential. So it's just trying to think a bit more about what arguments you might be able to make beyond kind of your traditional, if you like, arguments around childcare. I would also encourage you to consider not just the number of bedrooms, but also the location. There is little point in putting forward property particulars for a location that is clearly going to be inappropriate. The judge will likely have local knowledge of the area. They probably live in the local area. They will probably know where the nice places to live are and where the maybe less nice places, more affordable places, shall we say, are within their local area. They will know what you're trying to do. If there is a legitimate reason as to why they should relocate or remain in that particular more affordable area, then that's fine. But if there isn't, and it's solely to try and get down the value of the property, the problem is it's probably evidence that isn't going to be very persuasive and isn't going to be helpful. And then if you're met by the other side saying, no, I have to live in this area, and then they've only put forward very expensive, very nice properties, and you know that there are cheaper properties, fine, they might not have been as cheap as the properties that you've put forward, but they are somewhere in the middle. But if the judge doesn't have that evidence and doesn't have that information, it can be really difficult to persuade a judge at an FDR to agree with you. So again, it's just thinking it through. The other point I would make in regards to property particulars is please, in effect, check the maths. Is this a property that is actually affordable? As we all know, divorce sadly does not make people richer. It makes people poorer, and therefore for most individuals going through this process, they will probably have to move to a property that is more affordable. There is no point putting forward property particulars that even if your client got all of the equity, maxed out their mortgage raising capacity, they still couldn't afford it. It's not going to be helpful. And I generally find that judges aren't attracted to those kinds of arguments of, well, even if our client got all of it, they still couldn't afford this property, and therefore we need as much of the percentage of the equity as we possibly can. I generally find that isn't very persuasive in court, so it's not necessarily an approach I would recommend. However, of course, as already mentioned with area, please don't put forward unrealistically bad properties, if you like. So often I see nowadays properties put forward for shared ownership and leasehold. Now, it might be that's actually a fantastic idea in the circumstances because there are really limited assets in that case. But if it isn't one of those cases, again, it's probably not going to be very helpful, and it may well be more helpful for your client to put forward an affordable, so a cheaper property than what the other side say, but still to ensure it's in a decent location, it's a freehold property, and you may well find that's actually more persuasive. So you've done all your groundwork, you then turn to your offer. Now, in my view, what you're aiming for with your without prejudice offer is your best but reasonable outcome if it went to a final hearing. So everything goes the way you want it to at final hearing, your client is excellent in evidence, it's all looking good, but it's realistic. It's not something that the court would simply never do. Please bear in mind, as I'm sure many of you will know, judges can be quite robust in their questioning at FDRs. So it generally isn't helpful to put forward offers that are just simply something the court would never do. You want to present your clients as being reasonable, but you have a firm position. Equally though, please don't put forward offers that are too low. There can be a tendency, as we all know, amongst some judges to try and make sure that the parties can settle, that neither party feels they've completely lost in the indication. And there is always that risk of, do judges just gravitate towards the middle? Now, I think in fairness, usually they don't, but it's something I wouldn't necessarily want a client to go into an FDR with their opening without prejudice offer being what I actually think they should settle for. And I'm sure most clients probably don't need to be too, it's not too difficult to persuade them to perhaps go for the very best but reasonable outcome they could achieve. Maths, please make sure that the offer adds up. Please make sure that it makes mathematical sense. It can be difficult when clients are giving you particular instructions, and of course we are all ultimately guided by our instructions, but if you can work through the maths, if you can demonstrate that to a judge at the FDR, it is persuasive, it is helpful. That's why, again, it might be helpful to consider shared ownership properties if you simply can't get the maths to add up, for example. Also, think about the law. Do think about the legal principles. It might be that you have an issue over an agreement. Perhaps, the client, your client on the other side agreed something over the kitchen table, maybe not the wisest thing to do. Perhaps you need the judge to give an indication on that. Perhaps you need the judge to give an indication in regards to a pensions report. When think about the principles, think about the legal points that you want the judge to consider, and then work through what do you think those answers will be and see where that takes you on the maths. Now, of course, that's not how our clients approach these things, but it can be a really useful exercise because that is the exercise that the FDR judge is going to do. And it can be quite helpful for thinking of ways to justify your client's position and help them get to where they want to get to. Please make sure that once you have finalised your without prejudice offer, that you send it to the other side pretty much as soon as it's ready, and certainly no later than 7 days prior to the FDR appointment. It just gives the other time to consider it, to mull it over, whereas if they've only received it, say, the day before, 1, you're in breach of the practice directions, but 2, I think it can be quite difficult for them then to be in the right frame of mind for an FDR if that offer is still so fresh. You also might want to consider having a conference with counsel, even in the stages whilst you're still formulating the without prejudice offer. It might be particularly helpful if you are finding it quite difficult to get your client to where they need to be. Sometimes having just another person's view can be really helpful, and clients can also find very reassuring. And of course, it's not the be all end all, your without prejudice offer. It is a starting point, but it is very important, and it's certainly important when considering the indication. And finally, just on offers, please do make one. It can sometimes be very tricky to get instructions to pin clients down, but if they turn up at an FDR and they haven't made a without prejudice offer, they are at a real risk of costs. That's the reality of what's happening in courts today. So if nothing else, please do put forward an offer. So I'll hand back to Catherine.
Thank you. So at this stage, we've prepared everything in terms of compliance with the first direction appointment directions. We've also got our offer, which makes sense hopefully makes sense alongside the mortgage raising capacity and the property particulars. One of the final things to be preparing is the client. So when me and Hannah were talking about this talk, one of the first things that we were discussing is how important it is for the client to have realistic and to understand the expectations of them in relation to the FDR hearing. Clients having the right mindset coming into FDR appointments can help enormously in terms of outcomes. Let's start by looking at what the FPR says about FDRs. Rule 9.17 says that parties attending FDR appointments must use their best endeavours to reach agreement on the matters in issue between them. Another important thing to note is that subparagraph 10 of that same rule tells us that both parties must both personally attend the FDR appointment unless the court directs otherwise. I'm also going to be looking at what the best practice guidance sets out that clients should be told prior to FDR appointments. We as lawyers know that the purpose of the FDR is to enable parties to reach a reasonable settlement by agreement, and clients should be told the benefits of reaching such an agreement. For example, it avoids costs that have been mounting up to this point. It avoids further stress being placed on them, for example, being placed in precarious financial positions and their finances being left in the balance. The court will also expect parties to apply their minds to the possibility of settling, notwithstanding any offers that have been made in advance or the contents of the position statement drafted by counsel. And in order for an FDR to fulfil its proper objective, parties need to be told that they may have to compromise on their opening position in order to achieve settlement. For example, it's important to warn clients that they need to be prepared to be at court for considerably longer than the court's time estimate for the length of the hearing. For example, FDR appointments tend to be listed in the morning and start as early as 10 o'clock, but clients need to be told that they should be there for an hour before the listed start time. They won't be in court for the whole day. However, they will be expected to be in and around the court building and negotiating for the rest of the court day. Clients also need to be explained to about the privileged and without prejudice nature of FDR appointments. The judge will give an indication, but thereafter that judge will have no further involvement in the case. You also need to be discussing with clients the weight to be given to any judicial indication and the fact that this indication isn't binding. For example, there's no guarantee that this judge has made this decision at this time. However, there's no guarantee that a judge at the final hearing will reach the same conclusion. Whilst it's important to impress upon clients that it's advisable to be settling at, in most cases, at an FDR appointment, Clients should also be explained that there's no pressure, and certainly they're not compelled to settle at a hearing. And for example, a client might wish to give further consideration to any offer that's been given to them outside of that court environment. They may also wish to subsequently withdraw any offers which they have made but which were not accepted at the hearing. They also have the option to go to a final hearing, and clients must be made fully aware that they are able to do so. And whilst we've obviously touched on the benefits of reaching an agreement at an FDR, it is equally important to set out to clients that there are risks involved in settling at a high-pressure court environment. This is especially so where there are issues which remain uncertain on the day of a hearing or require further investigation. For example, there may be a pension report which is outstanding. There may be valuations which are outstanding, or disclosure which hasn't been provided. And in the event that clients wish to proceed in the absence of this relevant information, then this should be recorded in writing and signed by the client. It can also be made clear to them that they could make an application to adjourn to a second FDR, although there may be costs implications of doing so. It can also be helpful and good practice to ensure that clients are aware of court timetables in the event that an FDR doesn't settle, so that parties are aware that they might not have finality in terms of their finances for several or even many months, and the interim arrangements currently in place may need to continue. It also might be helpful prior to the FDR to consider having a conference with counsel, and this again can help manage clients' expectations. It's also helpful as counsel for us to know what advice the client has been given and their response to that advice. This could be done, for example, through the brief, or alternatively let us know and we can have a phone call prior to the FDR. I'm now going to be turning to Hannah, who'll be discussing what happens on the day of an FDR.
Yes, so you turn up at court, and I'm sure many of you already know, but if you are a training solicitor or if you are particularly junior, I would really encourage you to go on a day trip, go to an FDR. They are, in my view, very different. They're very different to other hearings. Normally you turn up, you don't agree, and the judge simply tells you, this is what's going to happen. But of course that doesn't happen in FDRs. They do have a different feel about them, so I would encourage you to try and attend if you can. So you turn up at court, I would speak to my client, I would confirm my instructions, I would repeat all of those client expectations, explain what they need to know, all the rest of it. And then I would go across to the other side, see if anything can be agreed, see if any further progress can be had. Sometimes it can, quite often it can't. And then you go into court and go before the judge. When, as I say to my clients, effectively what happens is the applicant goes first. They say, judge, this is what we think the correct answer is, and this is why. The other side, the respondent then goes, no, this is what we think the correct answer is and why. And then the judge turns around and says, thank you very much, but actually this is what I think should happen in this case. You then go outside the court room, but of course you don't leave the court building, and you continue to try and negotiate. Now it can take a very long time. Generally though, I find that you try and resist the temptation to kind of do incremental offers, because you don't have the time to do that, but you try and have meaningful negotiation, and then hopefully you reach agreement. But if you don't, you can always try and go back before the judge, when I'm increasingly finding that actually judges are quite happy to try and make time, for example, to deal with direction. But even more so if they hear that you are really quite close to an agreement, but you just can't resolve one or two particular issues. I think generally judges do try and help the parties settle. So apart from that, you will be outside of court most of the day. And as I say, hopefully you reach agreement, and if you don't, security will show you the door at some point. So there we go, that it really is a full day. Just to emphasise, because I know this comes up with a lot of my clients, as we all know, at FDRs, the court can't really deal with factual disputes between the parties. And that really links back to what Catherine was saying about the risks of settlement, that you simply may not know some aspects of disclosure or so forth. And it's really important that clients understand that the judge, in all likelihood, is going to be extremely reluctant or just completely refuse, quite understandably, to make comments about or give indications about factual disputes. The other point is, like I say, hopefully you do get an agreement. If possible, I know Catherine and I try and get the order agreed at court just because everyone is there. However, if the agreement is particularly complex, or for example, if you've only reached agreement in the afternoon and you don't have time to do that, you should always have rows ahead of agreement. It is important that even though they are not in, if you like, the form of a court order, that you get your wording correct, because they are an approved but unaffected court order. So it's really important to make sure that the judge approves them, and that you are content, your client is content, and certainly from our perspective, our instructing solicitor is also content with the wording, because as I say, it is a court order even if unaffected. Just very briefly, when of course you also have private FDRs, when that would be a whole other webinar. But the structure is effectively the same, just generally in nicer surroundings and often with food, which is always appreciated. But it still follows the same structure. The only difference really might be that, of course, you have one judge, and therefore if you want to go back before the judge, they're going to enable you to do that. That won't be a problem. Finally, you might just want to consider whether you want to attend more routinely FDR hearings. I generally find that clients really value and really appreciate having their solicitor there, or even not necessarily their solicitor, but someone from the firm attend. I know Kat and I always welcome attendance because it is a long day, and sometimes clients just feel a bit more comfortable making these decisions with someone they're a bit more familiar with, because it may well be that we're only meeting the client for the first time. But we always recognise that there are always costs to consider, and it simply may not be appropriate, but I would encourage you to consider that. So I'm going to pass back to Catherine to talk about after FDRs, and you've gone through that process.
Yes, so Hannah has dealt with what happens if settlement is reached in terms of drafting the order. But what happens if settlement isn't reached at the FDR? Even though the primary purpose would be to settle an FDR, it can be helpful to have draft directions in mind going into the day, particularly because if directions are being dealt with, this can be being done very late in the day, for example, at 3:30 when you've been negotiating all day and suddenly your mind needs to turn to directions as it looks as though there may not be settlement. In terms of some standard directions to consider for after an FDR, these can include Section 25 statements and also updating disclosure. You might also want to have a think about the schedule of deficiencies, which we discussed earlier in terms of if you have any further questions in terms of the disclosure which has been provided by the other side. You might also want to be thinking about questions to any experts that have been instructed. Also on the topic of experts is whether you're going to be looking to question the experts at final hearing, or whether it's sufficient for the court to be relying on their written report. You may also want to be thinking about any updates to any valuations which have been provided. It's increasingly common, for example, to have a valuation of the family home done prior to the FDA, but with current court workloads, parties may be waiting up to 18 months to 2 years between an FDA and a final hearing, and therefore it's likely that updates might be needed to these values. It's important to note that per the family procedure rules, there needs to be open offers within 21 days after the FDR appointment, or as otherwise specified by the court in the FDR order. This is under Rule 9.27a. Open offers also need to be done 2 weeks in advance of the final hearing. It's worth noting that a failure to negotiate reasonably and responsibly amounts to conduct for which the court can make a costs order, and therefore a failure to make an open offer can place a client at risk of costs. It's important that following an FDR appointment, the efforts to try and reach a settlement don't simply end at the FDR. Under the best practice guidance, even if parties don't reach agreement, the attempts to settle can continue by way of inter-solicitor correspondence, commencing the day after the hearing if necessary. It might also be worth considering whether to suggest holding round-table discussions shortly after an unsuccessful FDR, which can help you to capitalise on each client's newly redefined expectations. So that concludes our talking portion of the webinar, but we are open to receiving any questions at this stage.
But what we would say is that if something does come to you after this webinar, please do still raise it. And I know so few in our chambers will pass it on to us so we can get back to you in writing if that is helpful. We've just had a few.
So the question is, what proportion of cases settle in your experience at FDR? I'd say it's the majority.
Yes, I'd agree.
And I'd say that I don't particularly like putting numbers on percentages, but maybe 80 to 90% at an FDR or shortly after. It can be helpful in terms of parties have changed perhaps their expectations and have perhaps become more realistic, and they're more in the mindset of settling after an FDR.
So the other question that we have is, I think, a situation we've probably everyone's been faced with. So when property particulars are put to a client regarding their budget, etc., once you've got your mortgage capacity report, sale costs, what if they simply don't listen regarding their budget and needs? I think it's a very good question. What I would be tempted to do is, if your client is not listening, I would feel free to see if they want to have a conference with counsel. It may well be that hearing someone else's perspective, probably someone that's going to repeat what your advice have been, if they hear it from two independent sources, it may well just help to reassess their expectations. If that doesn't work and you've given them some time to think about it, then obviously ultimately we have to go with our instructions. I think as long as you've made your note, the client's been advised properly, you've made it clear, if they still wish to go ahead, then so be it. And they can see for themselves what might be the response of the judge, and simply, counsel will deal with it on the day the best way they can. But I think sometimes it is important to recognise that we can't always get our clients to where we might like them to be. But thank you, because I think it is important question, and to recognise the realities of our work.
So another question that we've had is, should all offers, both open and without prejudice, be included in the court bundle for the FDR hearing? In terms of without prejudice offers, the family procedure rules, I can't think of the number off the top of my head, prescribes that without prejudice offers should be provided in a separate bundle.
Yes, I was going to say that, separate bundle.
In terms of open offers, I think probably best practice would be to place them in the offers bundle.
I agree. I think also for simplicity, if you have your normal core bundle with your documents, and then you have a separate bundle with all the offers, that's going to be easier for the judge to navigate. Maybe slightly cynically, I'm also thinking if you can get more documents in that bundle, then perhaps you're going to have a few more pages for additional documents in the main bundle. So that's how we would encourage you to approach it. And then I think we might have time for probably one more question, and the rest of them we would get back via email. So there's one question on how would you deal with an opposing party that refuses to make an offer in the lead up or at the FDR? Furthermore, how do you deal with parties who make ridiculous offers in the hope the judge might make the parties meet in the middle? Now, your first question, I may be experiencing this for a hearing next week. So it's certainly something that does happen. My advice would be, first and foremost, you want the FDR to be effective because you want your client to have an effective hearing and to reach settlement. So your first port of call is chasing. And I think sadly, there is an element of being patient with the other side and just seeing what comes across. If, however, there is no offer being made, then ask for your costs. Fill out an N260, say to the judge they haven't made an offer, it's clearly in breach of the rules. There's quite nice little quotes and passages that you can now refer to. And yeah, ask for your costs, because it shouldn't be the case that your client is entering a hearing and the other side has simply refused to negotiate. When the second point is true, that if your opponent is making an offer that's clearly way too high, there is a risk, as you say, that the judge might simply go in the middle. But I tend to find in my experience that actually judges can react quite strongly to offers that are clearly way too high. And I think the point of meeting in the middle matters to a point, but only when the offers being proposed are actually orders that the court might make at a final hearing. If it really is completely out there, the other thing that counsel could say at the FDR is just a moment, we are under obligations to negotiate and to negotiate reasonably. This offer is clearly not appropriate, and kind of put pressure, if you like, an uncomfortable pressure on the other side that potentially they could be staring at a costs order. The other thing, of course, is that whenever you get the indication from the FDR judge, we always give our advice as to whether we actually think that's a good indication, because we all know that sometimes indications can be better than others. So if the judge does go down that route and does simply kind of meet in the middle, they will hear that advice from counsel that that's not perhaps a figure they should settle on. The other thing is the other side's counsel will know that as well. And I don't think it necessarily stops you from reaching agreement, though I acknowledge that it does make things harder. But I would hope most of the judges we're before would quite clearly see it for what it is, and it can certainly back up. So I think, Katrin, we're probably finished for now, so I will pass it to you.
We just wanted to thank you all very much for attending. If you've asked any questions through the Q&A feature, but we haven't answered them, they will be followed up by email. The recording for this webinar will also be available from tomorrow. The next webinar in this series will take place on Thursday, the 1st of June, where Eleanor Berthelsen and Samuel Davis will be discussing experts in private children law proceedings. So please do tune in for that. Thank you very much.
Thank you.